Bismillahirrahmanirrahim. Welcome everyone to a special live podcast by the Research Society of International Law on a legal stock take on Kashmir on the occasion of 5th August. The Research Society of International Law is Pakistan's oldest, largest legal think tank. My name is Jamal Aziz. I am currently serving as the Executive Director of RSIL. I'm joined here today by Mr. Amr Bilal Sufi, the founding President of RSIL, and Muhammad Awais Anwar serves as our Director Research. On the second anniversary of 5th August 2019, where India unilaterally altered the status of Jammu and Kashmir, stripping it of its autonomy and splitting it into two union territories of Ladakh and Jammu and Kashmir. We are faced with the issue of looking at the different developments, and our task here today is to look at all of these from a legal perspective. Now, India terms this as an internal matter, having no bearing on the UNSC resolutions on Kashmir or the Simla Agreement. Pakistan, on the other hand, terms this as a clear violation of international law, an occupation which is now an illegal annexation, a grave breach of the UNSC resolutions on Kashmir and the Simla Agreement. In the past 2 years, several key developments have taken place. Firstly, the situation in Kashmir remains very tense. More than 730 days later, there is no normalcy. State of lockdown is ongoing. Some have compared this to a siege under international law as well. A series of legislative and administrative measures have been taken by the Indian government, including demographic changes, stripping away autonomy, application of Indian laws, and repeal of state laws. Multiple challenges have been filed before the Indian superior courts, especially the Indian Supreme Court, challenging the actions of 5th August 2019 and the subsequent administrative action. Meanwhile, there is a rising threat to minorities in India, in mainstream India, especially Muslims, as witnessed by the developments following the Citizenship Amendment Act, the Babri Masjid verdict, and mob violence. Coupled with that, on the Pakistani side, Pakistan has tried to lobby and promote the cause of the Kashmiris at international and domestic forums. It has issued a new political map, and there is considerable debate today on the future status of Gilgit-Baltistan and the constitutional arrangements for AJK. This is a debate where there is some degree of politicization and polarization, which we hope to discuss today as well. Meanwhile, Pakistan has also started asserting that India is fomenting terrorism in the country, sponsoring terrorism in the country. It has released a dossier last year documenting these incidences, and recently in the Johor town case, it has provided evidence and proof of Indian involvement. All of this is in an environment where there is still some scope for dialogue. We've had a ceasefire agreement earlier this year, and the Islamabad security dialogue, Pakistan has indicated a willingness to move ahead, provided conducive environment is set forth for dialogue by the Indians. This has also led to some controversy and confusion. And in the meantime, the overall, I think both sides are agreed that there is a need to talk about regional development. There's the emerging challenges of climate change that are around the corner, water wars, poverty alleviation. And so for all of this today, we are here to discuss this from a legal perspective. We're not going to talk emotions. We're going to try to stay away from rhetoric, which is what the basis of RSIL's philosophy is, and try to unpack all of these from a legal perspective. Sir, I will begin by welcoming you to this live podcast. And sir, if you could make us go through the different legal steps which the Indians took in the days and months prior to 5th August. As lawyers, you have often talked about the legal significance of the different moves that the Indians have done. So what in your view are the key developments?
Well, thank you, Jamal, for the opportunity and in this podcast on a very important subject that is very dear to people of this country. Not only dear to people of this country, all I see, all is that are sensitive. All states have sponsored discrimination as a legal argument over decades. UN General Assembly, UN Security Council, and even outside. Uh, I and you know as lawyers that self-determination is an major, uh, major argument used by the accepted only in two states. One is the Palestine and Kashmir. In all other areas, wherever you make an effort to self-determination, uh, is questioned. But in case of Kashmir, there's been a unanimity over state practice stretching over decades that Kashmiris are entitled, and this is because we had an instrument of which is conditional. Based on that, we had several UN Security Council resolutions, UN CIP resolutions, Security Council constantly recognizing that right. In the first decade of its inception, we had a very strong representation in the UN Security. Sazafullah Khan. Arguments were absolute. And the Kashmir case was brought to the forefront of the world agenda. And thereafter, we had things slowing down in terms of raising the matter of Kashmir before 70s and 80s, even in 90s, till we did nuclear explosions. And when that happened, the Security Council became alive to this concern that these two neighboring countries who are nuclearly armed or potentially getting nuclearly armed in 1998, they said they must resolve their issues, including the issue of Jammu and Kashmir. So that was after a long time that Kashmir returned by specific reference in the Security Council. Now, on the Indian side, since India was also bound, Nehru was also bound by the conditional undertaking. So while they had occupied a territory in the valley and they were exercising occupation, but that occupation was not backed up by a proper legal title under the Constitution of India. Because whenever the constitutional document of any country is structured or made, one of the basic functions of any constitution is it's a title document of the territories. In our constitution, for example, the territories are listed. In any constitution, the territories are listed. In the Indian constitution, the territory of Jammu and Kashmir that they occupied has not been listed as an integral part of the territory of Union of India. Instead, it enjoyed a separate category, a separate legal treatment. And that legal treatment was provided for in Article 370. And it was well recognized throughout the Indian state practice as well that this article cannot be dislodged, it cannot be altered, it cannot be amended by virtue of multiple constraints in the Constitution of India. And it can only, you can move forward beyond 370 only if you are conferring the right of self-determination on people of Kashmir. And thereby, you are able to bring it back or give a status as per the UN resolution outcome. RSS and the current party led by Mr. Modi and the other, they had an intent up front that they would like to firm up their title on Kashmir. They would like to remove this defect, so to say, in the title, which has been created under Article 370, an encumbrance on the title. Everyone was of the view that this is extremely an ambitious election agenda. It can't be done. You need a constituent assembly which no longer exists. So how can you think of even removing Article 370? But once they came to power, they started planning on that. And as like management team which ticks all the boxes that it has been talking about in the election campaign, whether it was a box of Indus Water Treaty, they actually considered cancelling that, abrogating that. But they realized that legal constraint prevented them from doing that. Likewise, they said we need to get rid of Article 370. So for that, I think they had a team of lawyers which worked extensively on how to do this. Now, they came out with an innovative solution, which also to some appears to be a lawfare move by India. On 5th August, very quietly, without any earlier notice to any country for that matter, there was nothing written, nothing spoken with reference to that, and suddenly you are tabling a legal instrument which is so comprehensively drafted, which dislodges Article 370, 35A, and you claim now Kashmir is ours. Not only that, you make an extraterritorial claim over the title of the Kashmir that Pakistan is exercising control on, which is AJNK and Gilgit-Baltistan. You don't stop there. You claim territorial title with respect to the property or the land that is with China in Ladakh. So suddenly, this exaggerated assertion of claim through a legislative instrument was unsettling for the entire world, including Pakistan, including Kashmiris, that we thought that we are supposed to have a dialogue or a framework. So I think
Which was the spirit of Simla Agreement as well.
which was exactly the spirit of the Simla Agreement, that if fine UN Security Council resolution is one lane to walk through for getting Kashmir towards a resolution, the other lane, which was optionally available to both the parties, is a bilateral framework. Again, it's a unilateral arrangement. So I think that is why it has been severely criticized, and India has not been able to gain an endorsement from any international power so far, P5 power or whatever, saying this is a valid treatment they have accorded to 370.
Thank you, sir, for that very comprehensive overview, giving us a bird's eye view of developments. Avais, you've been working in the field of the law of armed conflict. You were heading the Conflict Law Center at RSIL for many years as well. Pakistan's position has always been that India is an occupying power in Kashmir. And if the law of occupation is essentially the law of armed conflict, it comes with certain responsibilities of the occupying power, certain things that you can and cannot do. But India now treats this as an internal matter. It denies that this is an occupied territory. It regards Kashmir as an integral part of India. How do you see this interplay between what India is saying and what international law requires? And if Pakistan's position is correct on international law, how do we seek accountability for the Indian violations?
Thank you very much, Jamal. Jamal, I think that's a question that has a lot, built into it, and I think we need to unpack that. When we say that, the territory that India currently exercises control over is occupied territory, that's particular phrasing. That is international law phrasing, and as you rightly mentioned, that is phrasing in the context of international humanitarian law. And international humanitarian law, as we all know, is the law of armed conflict. When we say an occupation, we are talking about unconsented, when India exercises unconsented to effective control over territory it does not have sovereign title to. So we're clear on these things. First, the people of Kashmir have not been given the right of self-determination, therefore they cannot determine or give the consent to allow the Indian forces there.
Very right.
Correct.
The second point is that easily you can establish that India, with its 700,000 to 900,000 troops there, one of the most militarized zones in the world, exercises effective control. So that's clearly there. Does it have sovereign title? So we have to go to the instrument of accession, as Ahmed Sufi Saab mentioned. The instrument of accession, as when it was accepted by Lord Mountbatten and then by Nehru, statements within a week of that. In fact, the acceptance letter states that a condition of this instrument of accession is that the people will choose who to go to.
And in fact, Article 370 was supposed to give constitutional effect, as per
Exactly.
Nehru,
Yes,
to
that-
the
that's
instrument of
proviso.
accession.
Absolutely. So two things. 5th August has vitiated the terms on which Kashmir acceded. So that relationship does not exist anymore. That's number one.
That's a very interesting point, Avais,
Yeah.
because if as per your argument that relationship doesn't exist, a lot of legal consequences follow from that.
Absolutely, and I think that is something that hasn't been explored in a lot of detail, but it certainly has, from an Indian point of view, and especially some of the Supreme Court judgments and especially the High Court judgments from Kashmir, they talk about this point, that the terms, the basis on which we acceded, and the limited accession that took place, was based on the instrument of accession, which now has been vitiated in that agreement there. Now, I want to come to the question of accountability, which you mentioned. If we look at it from an international point of view, the original sin or the original illegality that took place was not granting them the right of self-determination. And from that then flows all the other illegalities that have taken place. So every appointment, every military operation, every military deployment, every atrocity, well, atrocities in any case, but every government quota that is established or every domicile certificate that is issued, that is an illegality because of the original illegality. And from there, what we see is attempts at trying to cover that up, or attempts at not allowing a peaceful or just settlement to occur. So, for example, evidence of, say, India's guilty mind or mens rea in this sense would be, it's closed all doors to any outside arbitration. It keeps on wanting to do this as a bilateral issue. Its declaration to the ICJ prevents Pakistan from taking this matter to a third neutral arbiter.
And its argument that UN Security Council resolutions are a flux of time issue, as opposed to what
Exactly.
impact it has on the legality and the original.
Exactly. And it's
Which I disagree. I think the UN Security Council resolutions are a very concrete legal instrument.
Absolutely.
Yes, sir.
They exist as a milestones, and every UN Security Council resolution is entitled to serious respect by the member states, whether it is under Chapter 6 or 7. If this argument is allowed to fly, that resolutions by a flux of time have become irrelevant, then that would be a very difficult situation, because you have resolutions of Security Council that are being passed in 2021, in 2020, in 2019,
Of course.
18, 17, etc.
course.
So member states are supposed to, and as long as they exist, either they should be rescinded, they should be recalled, they should be specifically set aside.
Yes.
Till then, they hold the field, legally speaking.
Absolutely, sir. And just coming back to the point of accountability, there's two, forms of accountability that we're talking about. One is the original accountability for the violation of the right of self-determination, and that, of course, is the core of the entire dispute between Pakistan and India, and the people of Kashmir. And secondly is the specific violations that are taking place on a daily basis even till today, and for the past 7 decades. And that is Indian troops, Indian security forces violating the rights of women, children, men, everyone in Kashmir. So as an occupying power, you have certain obligations on you. And we have the Fourth Geneva Convention that gives us a lot of detail there. But you also have India's own laws. And India's own laws are being violated by these officers. And now, when such international crimes or even domestic crimes, the primary obligation to hold accountable these violators is with the state. But what we've seen in India again and again is permission is required by the central government, from the central government, to prosecute a soldier or somebody from the security forces. And that has been routinely denied. So there is impunity along with the violations that are taking place, and that's what perpetuates further violations from taking place. Then at the international level, if the state cannot do this, then it goes to the international community. And that is really where...
The principle of complementarity.
Absolutely, sir. And that is where now we find ourselves in. Will the international community wake up to take cognizance of this, of these violations that are taking place? And we see some movement towards that. And that is something that is encouraging, but of course it's coming at a pace that we'd like to be a lot faster, and especially the people of Kashmir would like to be a lot faster.
So you have seen the development of international law over the past 30 years and how it was in the days following the UN Charter. The mechanisms for seeking accountabilities, they were much more formalized. But now we are seeing a trend of individual states also legislating for the protection of human rights, for the protection of humanitarian laws. Does that provide an avenue to the Kashmiris to utilize these, and what are the forums and avenues? Pakistan, there is often this discussion, where should Pakistan go? But I think the question is, where should the Kashmiris go, and what countries can support them, and how?
You see, traditionally, sovereignty was viewed as confining to the territorial boundaries, and therefore, legislative function would also be confined to that. That you could only make laws with a reference to your state territory and nothing beyond. But then we had this concept of extraterritoriality, that if there are events that take place outside your state but they have an effect or link with your state, or an individual has a nationality, then you are entitled to make legislation which is of extraterritorial nature. United States, for example, is one of the main players which is into extraterritorial legislative measures are taken by them in respect of individuals, entities, and countries. Nothing stops any country from making a law which is relating to human rights that has an effect in that country. For example, if there is a situation of atrocity against a certain group or against a group of Muslims in India or inside Kashmir, which has an effect on certain people within Pakistan, a commoner, a group member, a non-state actor, a madrasa people who go to mosque, and when they hear what's going to happen, they are outraged in terms of what's going on. We want to do something. Now, this means that that the effect is happening in your country of a development that is taking place outside. So then you have entitlement to make legislation to handle the effect and consequence. that legislation could take a shape of human rights framework in which some mechanism is embedded for accountability. Some countries have it. It's a matter of political choice, really, more than the legal choice. And it has to be the government and the political forces of the country which have to come together if they want to go down this route of making extraterritorial legislation. Some countries have it and they allow that. So you had a universal jurisdiction concept once with Belgium, where you could frame charges against anyone who has committed war crimes or who has violated Geneva Conventions.
Yeah.
You have some other countries.
Argentina
which
has
still have,
a
Argentina has a
Germany,
framework.
the UK,
Germany.
a number of countries in Europe especially have those.
They have this opportunity, and which means that Kashmiris, wherever they feel, or somebody else, contract law, CRPC, PPC. So, and therefore one always has a higher bar of expectation from the Indian Supreme Court. And a few years back, they had some very independent judges who were giving a serious time, or tough time, shall we say, to the government in hand. But now I believe it appears that Supreme Court of India is not responsive as much as it should be. They have this petitions pending against Article 370. Initially, I think 2-3 years back, there was a petition which was dismissed. And yet this matter is again pending. And there is yet another very interesting dimension that the people in India need to bring to the attention of the Supreme Court, which is that what Indian Supreme Court needs to do is to scrutinize the actions of the executive arm of its state. The executive arm of its states undertaking such aggressive legislative steps that can lead to a war-like situation, which in turn can jeopardize the right to life of the people in India. So to protect the right to life of an ordinary Indian citizen, it is their obligation to take cognizance of this entire issue and see if this legislative action is an overreach. And as said by multiple Indian lawyers, that it is an ultra vires act. So it has not only domestic repercussions, but it also has bilateral and international repercussions.
Especially the way, sir, I completely agree, because especially the way the legal acrobatics that were conducted to make this move go through, especially for me, the biggest one is the fact that they changed the definitions in the Constitution by amending Article 367, and then by saying that the Constituent Assembly means the Legislative Assembly, and then by saying that because the Legislative Assembly is not in operation, because there is governor rule in J&K, the Indian Parliament can be a substitute. Now that has very dangerous implications for Indian federalism, because Indian Constitution itself says that whenever you want to change the boundaries of a territory, it cannot be done without taking that state's legislative assembly into confidence. And so that creates kind of implications, and that is what I think many of the leading Indian lawyers have been arguing this. Avais, I want you to also add on this, and also your view that there is also this allegation being made that the Indian judiciary is either developing a bias or it has been suppressed
by the executive
because we've seen the Babri Masjid verdict come out, and a lot of other developments taking place as well, some Jhota Express, all these different things in which the judiciary has been kind of in a way looking the other way. Do you think that is a valid concern?
So I think, Jamal, this, again, this is outside of the legal realm, but it's something that, really affects the legal realm in any case. So I want to discuss it. And it's something to look at the bigger picture. What's happening in India is that, society is being transformed. And it's very concerning from a Pakistani perspective, but I think it's more concerning from an Indian perspective. And whether you're following this on, in the media or not, but it's very clear that Indian society is changing. And that there is a fundamental encouragement of this change by the current government, the BJP, RSS influenced government. And
it reflects in their culture, in their movies, in their programs, and in their approach.
Absolutely. The media, for example, I mean, you're not going to find medias around the world which are as, towing the government line as you see supposedly free Indian media, sadly. But then again, you have excellent independent voices as well. But the concern here is that there is no limit to which they'll go. Because right now, the actions with Kashmir, for example, that blinded by bigotry and by religious hatred and Islamophobia, they were willing to, sacrifice the sanctity of the most sacred document in Indian democracy, the Constitution. Because the method by which they did this is not something to be proud of. They were sneaky. This was a dastardly act, if anything. This was not the way a constitution, should be amended, and especially something that affects the lives of millions of people, the territory of your state. So I think that is something that is certainly of concern there, and that's really what is then being translated into because society is putting these pressures out as well. It's not just, say, the executive arm, that the judiciary is being affected as well. So I certainly hope that the judiciary is biased. There is no bias within the Indian judiciary, because we have for so many decades looked up to the judicial decision making and the.
And you are right, Awais. Their judicial views on 370 were completely opposite to their legislative action. Their legislative action is not in conformity with what their judiciary have been saying about Article 370.
Exactly.
And their Supreme Court and Jammu and Kashmir High Courts have been saying repeatedly that there is
it has acquired permanence.
It is acquired permanence, and that 370 designates also they have the state of Jammu and Kashmir, which they occupy, retains certain element of sovereignty. Those are the phrases, very key phrases. It retains an element of sovereignty. When I read it, I remember for the first time I was taken aback that a domestic court and of a state itself conceding that a state which is part of us, that we exercise control on, it still retains an element of sovereignty. So you would notice that it is one of the very few states which retains an independent flag. And there's a flag act or something, I don't remember the name. And there's a judgment on that as well, which says it's an obligation to continue to, hoist the flag of state of Jammu and Kashmir. So it's quite an extraordinary judicial appraisal and judicial assessment of the relationship of Jammu and Kashmir, as it were, with the State Union of India. And the legislative action is completely on
all
the,
the
in
more
the
reason,
opposite
sir, why
direction.
we were expecting that the Indian Supreme Court or the Superior Judiciary would push back, but that has not.
And I
yet
haven't
happened.
seen these judgments being set aside.
Yeah.
One of our teams has been following that. I don't think that these judgments still hold the field.
Absolutely, sir.
And certainly that's a consideration that the Supreme Court will now have to look at. But the only concern is that we see how fragile, legal systems, especially in our region, have been. With Samjhota Express, for example, it was a prosecutorial failure there, and that is what the judiciary said. The Babri Masjid case, I think, it's something really concerning with regards to Kashmir as well. So those are, trajectories that we would hopefully not see, not just for our sake, but even for India's sake.
Absolutely.
You don't want to
And
go
for
down
for the region.
Yeah.
Coming now to the Pakistani side, we've talked about India and also speculated about where things are headed there. But on the Pakistani side, a lot of different developments have taken place on our end. I think the main thing from a legal perspective, which any Stocktake has to kind of focus on, is the new political map that was issued by Pakistan last year on the occasion of 5th August. So you've been talking about Pakistan putting its territorial claims, reflecting them in a map for 20 years now. I think that must have been a welcome development in your eyes. So, sir, if you could talk about the key features of this political map.
Yeah, first of all, I would like to welcome the map. I think it was long due. The Survey General of Pakistan is an executive office which now has a legislative cover, and the job description under the Act is to identify the territories of Pakistan. Now, maps are a very key evidence of assertion of claim discussions at international law level, and they play a vital role. In the Sir Creek issue, Pakistan and India both have been relying on the maps by the Survey General of India, various versions of that map, and obviously there's a conflict. But maps are key when you are talking of territorial control.
In any dispute or any negotiation in the future, any forum, it will be
Between
the
any
map.
countries,
It will
not
be
more
the map.
between Pakistan and India.
Yeah.
So when we had an argument on NJ 9842 with reference to Siachen, the line of control extends, it needs to go further. I'm glad it has now been reflected in this map. So that's very important legal position that has now been reflected in the map, that NJ 9842 stands extended towards
the
glaciers in accordance with the previous course of direction. That is something which was critical.
Absolutely.
And whereby the Siachen glaciers fall on the Pakistani side. The second important legal feature of the map is the Sir Creek, where you have a concave coastline, And again, there's a reflection that Pakistan's asserted claim on Sir Creek is being reflected in terms of the concave coastline
On the
and in
eastern
terms
side.
of a line which is extended from there.
Yeah.
The third significant, I think, addition or something in the map is the Junagadh state coming back on the map. It's come after a little gap. Junagadh state is also has an instrument of accession, and if you have a legal instrument, which is a title document, even if the occupation was with a third party, you still have to assert that title. You still have to show it belongs to you.
Sir, people in India and generally have criticized the Junagadh move there because they said that this is now a non-issue, and why does Pakistan want to just theatrics? Why should it? It's not nearly as disputed or contested as Kashmir. Is considered a settled part. So, sir, what from a legal perspective, why is Pakistan taking up this
Again,
issue?
we three look at things from a legal point of view.
Yeah.
Research Society looks at things from a legal point of view. A political perspective, a historic perspective certainly has its value. But obviously, we're looking at from a legal point. As long as there exists a legal instrument which says the title stands transferred, I am part of this country, then that document is there. Unless it is changed by the family of Nawab and the government of India, it is holding the field. It is applicable to the successors of both the sides. So that's the legal position. We understand that the occupation is with the Indian government for last several years and so on and so forth. But if you have a legal position which is giving you a dividend, then you are taking it. And it's a game of lawfare now, and you see what they've done in terms of on 5th August. They've innovated a very out of the box kind of a legal instrument to assert claim over the territory of, whereas we have a straightforward instrument of accession with Junagadh state.
Sir, closely linked to this question for both of you is that we have issued a map, but some have been arguing that a map simply is not enough, and now we need a composite legislative instrument that also reflects our territorial claims. In that, sir, the biggest question now is GB and the future constitutional treatment that we gave to AJK. This is something which I believe has also been politicized a bit. There's a certain element of historical polarization on this issue as well. And there was, I believe, the Sartaj Aziz committee report looked at this issue in a lot of detail. The Supreme Court gave a lot of clarity. All of us working in international law know that changing the status of GB will not, provided certain safeguards are maintained, will not affect the position before, our principled position before this. Why then, sir, is there so much controversy and confusion on this issue, and how can we kind of tackle this?
So I think Sufi Sahib is probably the best person to discuss, but I just wanted to discuss, you had mentioned the issue of politicization. I don't think that, recent statements of these things should be read much into, because, it has been an election year in AJK, and
Yeah.
that sloganeering and all of those things. So when it comes to the issue of Kashmir, GB, this, your opposition and your treasury benches are all on the same page. And we're grateful for that. I think that Pakistan knows as a nation what our strategy is on Kashmir. At times, it can go ahead.
So you
and
won't
there,
read too much into what
I wouldn't.
until something has actually
exactly.
happened.
And
I think I agree with Awais that it's more of an election momentum. But legally speaking, as you asked, a legislative instrument is not a compulsion, but it is a preferred option, because a state has to assert its sovereignty through legislative. Even this map is technically an executive action, so you could do it through a judgment of the Supreme Court. You could do that through executive action or legislative action. Now, the nature of legislative action is what do you want to do with GB, because there are some internal compulsions in addition to international compulsions. International compulsion is you need to make a matching move because the Indians have done it, and they are claiming title. You need to neutralize that attempt to gain title over GB. That's the international compulsion. Domestic compulsion is you have a judgment of the Supreme Court, two judgments of Supreme Court, one authored by Justice Ajmal Mian, one authored by Justice Saqib Nisar, in which they have said give them rights.
Fundamental rights are not being according to the people.
And you have been exercising control over them continuously, uninterrupted control. they carry your passports, they carry your ID cards, they use the same language, the same currency. All elements of executive exercise of authority are demonstrated. So what is holding you back from giving them the rights of representation?
In fact, sir, some argue that under international human rights law, we are obliged, there's a compulsion to provide fundamental rights to people who are subject to such control. Would you agree with that?
Absolutely. I think affording human rights becomes a priority of a state regardless. Right? If you exercise control over a certain territory, that is your obligation. As long as it does not affect the ultimate, plan within the UN Security Council resolutions, where there can be a plebiscite, a reference to the people of, the overall state, former state of Jammu and Kashmir. Unless that is not affected adversely, I think there is absolutely no limitation there.
I think I would like to add to that. There has been a certain element of, I would say, duplicity on this by certain actors, because in trying to say that Pakistan is also doing the same for GB, also, so that means that we are basically replicating what happened on 5th August on our side. But I think that is a false equivalence, because Article 257 of our constitution remains intact.
Exactly.
And we are not saying that we are denying the right to self-determination. We are not saying that this is an internal matter of Pakistan, that there is an integral part of Pakistan.
And it also depends how do we frame our law, the draft law that is being talked about for the GB incorporation. The language of that law will be crucial in making a clear assessment if our position on Kashmir, the stated position on Kashmir, stands compromised or not. In my view, if you have the right kind of language, you are able to manage that expectation.
And so, sir, in your view, it is most likely to be a provisional kind of a constitutional status?
It has to be a provisional constitution. It is subject. It has to be tied up.
Yeah.
It has to be kind of a contingent framework, contingent on whenever UN Security Council is ready, prepared, and all set to undertake the plebiscite, then we will undo this process, and that will be in accordance with our stated position.
So changing the topic now to something which has always plagued Indo-Pak relations, and this is something which we've seen a big shift happen as well in terms of development, the issue of terrorism. We saw that the terrorism argument has been used by India as early as the 80s to deny dialogue. After 9/11, it became the basis of their policy, terrorism first. But in recent years, we have seen, especially as evidenced by the capture of Kulbhushan Yadav and then subsequent actions, that now there seems to be irrefutable intelligence proof in information and material that India has been involved in supporting terrorism in Pakistan, fomenting unrest, violating the principles of intervention and non-interference. And now Pakistan came up with a dossier last year. How do you see, and now in the Johor town attack last month, the Pakistan National Security Advisor has provided an official briefing in which we have said that we will be releasing irrefutable proof that this was masterminded by the Indians. So, sir, you have been working on this area since 9/11. You've been one of the first people in Pakistan to talk about the importance of UNSC Resolution 1373. In fact, the first seminar which RSIL conducted on these new legal frameworks took place as early as October 2001.
That's right.
And since, and you have seen this evolution in the Pakistani stakeholders. We've gone from not understanding these frameworks to now, because of repeated FATF grey listing, becoming very comfortable with these international. So how do you see this evolution? Is this because Pakistan has itself understood international frameworks?
I think it's Pakistan's own internal self-realization which has a lot to do with this, and I think which is very positive. Frankly, I think if you remember, one of our initial slides in our talks has been responsible Pakistan. That RSIL is aiming for a responsible state which honors its obligations under international law, whether they are obligations relating to protection of cultural property or environment or climate change or non-intervention, and preventing terrorism on its own ground. This is an international obligation, and we should be doing that. And I think there's been a sea change in the approach of even the state institutions within the country and the political forces, that they do not want to be now coupled with any reputational damage associated with non-state actors doing anything beyond the territories of Pakistan and even within the territories of Pakistan. And that is a sea change, and that's a very positive development. But unfortunately, the other side is now beginning to invest in non-intervention incidences, a breach of the principle of non-intervention. It is now beginning to sponsor terrorism, and we are, as you rightly said, we are now finding those proofs, those evidence, those digital evidence, where one can track the money trail going from the Indian,
Accounts to
accounts to terrorism and terrorists and so on, so which is very unfortunate. But then Pakistan needs to raise this issue at international forums.
Yeah, absolutely.
Aves, you've been working on criminal justice issues for 10 years now on this, especially in the context of international counterterrorism frameworks. Pakistan came up with a very comprehensive dossier last year, towards the end of last year, but we've not seen the kind of traction that dossier for that dossier as, for example, the dossiers which the Indians presented after Mumbai or Pathankot or different things. So, is this what do you attribute as the major reason for that?
So Jamal, I think what you earlier mentioned, that we have very credible intelligence that India is involved in terrorism. I think that's really where the issue is. We have to start engaging in a process of converting intelligence into admissible evidence in court, or admissible evidence for a mutual legal assistance request, or something that we can attach to these files and go to the source, whether these are Indian banks or whether these are Afghan banks or whether third party banks, if they've been channeled through different locations, and we need to be able to ensure that we have a chain of custody of this evidence. This hasn't we haven't had to send spies in to take pictures of certain documents, etc. These are things which can be verified by third parties. I think that is one thing that will certainly
and I
shift
think the existing investigations in Pakistan on so many terrorism incidences that have taken place, I think those investigations have to also be amended with these new developments. Like those things have to reflect in the investigations by adding these new developments through a legal process.
Absolutely. And one very interesting point.
No, go on.
So one very interesting point is that we have seen in Pakistan terrorism investigations, the quality improve. You have your provincial counterterrorism departments, which have been a sea change in how they've started doing investigations. We have amazing forensic science labs.
The financial monitoring unit.
We are now starting. It's still in its nascency, but I think a huge area is mutual legal assistance with other countries. And what's perhaps most interesting is this probably wouldn't have come about if it wasn't for FATF, the grey listing, which was, as Mr. Jaishankar, the Indian Foreign Minister, mentioned, was on India's insistence.
Yeah.
Right. So really, this capacity improvement has been a result of Indian pressure in a different department. But I think the goal ultimately is converting intelligence or making it an evidence-based process.
And I think there is also a political side to mutual legal assistance between two neighboring countries. The political side is that you are able to understand it instead of as we say, a war approach. You prefer a law enforcement approach.
Yeah.
That is much better, because then you begin to sound genuine to each other and gradually mature your responses as well.
It disciplines your responses because you realize that this is something that can come back at you.
Come back at you. And the more you engage in mutual legal assistance, the more both the sides will begin to sense the significance of self-disciplining their operations vis-a-vis each other.
Sir, I want you to just add a bit more on what I've said, because you've often been talking about how domestic proceedings before our courts, before the lower courts, the trial courts, how they have such an impact internationally as well. So how can we give this broader lens to our own investigators, to our own prosecutors and our own judges? I remember, sir, some years ago, you were an amicus before the High Court, and even then the court, even at the High Court level, was not able to appreciate the importance of UN Security Council framework. So how can we expect a trial court to do that?
Well, I think that's a very valid point. I remember, I won't name the case, but in one of the major cases, from Sindh High Court going up to Supreme Court, the order which admitted the petition said there are important law points that need to be considered. And the first law point was whether UN Security Council resolution is binding under Chapter 7. So, and I was taken aback that, you need to assess your courts, the higher courts and the Supreme Court, on the points of international law. on the points of significance of international law and its impact, because the state's judiciary also is viewed as a subset of the state from an international point of view. It
Absolutely.
may be independent in the state, but it is not independent from the state.
Yes. Okay.
So the judgments of the Supreme Court or High Court or lower court or trial courts, they serve as acts of state. So if someone is acquitted or someone is not convicted, either way, or is convicted, it is viewed as an act of state. So therefore, I think, and given the fact that we are now all involved in transnational trade issues, transnational human trafficking, transnational crimes, transnational corruption matters, transnational wildlife trade, transnational so much that you now has transnational criminal gangs. So one is sitting in South Africa, one in Thailand, one in UAE, and they are cooperating to create an occurrence in yet another state. So we have a very complex world which has come together in a digital platform, and it has become very intimate. And now to consider that the sovereign identity, which is linked with territorial outlay, should be stuck with, and we should be frozen with it, is something we need to get out of that.
Absolutely. So, and if I could just add, I think I'd go just a little bit further and say that when it comes to our international obligations, I think what the judiciary needs to understand is there are some obligations that only the judiciary can discharge.
Yes, that's true.
Not only is it part of the state in discharging these obligations, but it is the only entity within the state that can really discharge this effectively. And especially when it comes to our counterterrorism or counterterrorism financing, money laundering, FATF-related issues, the judiciary plays a very important role there.
We've seen Pakistan, there is a trend now to talk about this word lawfare, lawfare, lawfare. And I think lawfare, okay, we've seen because the attacks against Pakistan have been so blatant and so often we've seen in the past couple of years that there is now realization that international institutions are becoming weaponized as we are heading into a multipolar world. Obviously, you're seeing unilateral measures coming in and countries increasingly relying on legal measures to force changes. That's one side of international law, but on the other side, international law is broadly traditionally meant for cooperation, for promoting the common good, for dealing with the global commons and all those challenges about. Broadly speaking, and sir, when you started RSIL 30 years ago, that was your
That
vision.
was the purpose.
That was to develop that capacity. Sir, how do you see this evolution of the capacity of international law? How do you see state institutions responding? And how do you see it going forward?
Well, I think they are realizing it today. Once we started off with the RSIL, as you said, almost 3 decades ago, people weren't aware of it. People would laugh it off, and people would view that this adventure that they assumed we are doing through RSIL won't take us anywhere. But I think it has done its contribution in terms of creating awareness that, look, there is a discipline called international law, which is important enough that you need to focus on it. And our vital interests are tied up with that. Our political interests are tied up with that. Our strategic interests, our regional interests are tied up with that. And it can be used both for lawfare, for offensive, defensive, and also for opportunities. I mean, the international treaties provide so many opportunities for a country, for a region, for several countries to do so much. The WTO is essentially a document of opportunities. It's a treaty based, which is telling countries, if you do this trade this way, this is the benefit you will get. So if you are able to identify opportunities in conventions and treaties, you are able to leverage international law in a positive sense. And that is, I think, we should be looking at. For example, in a region today, the transit is, I think, an area that we need to explore. And the transit convention, transit treaties need to be looked into.
Yes.
Absolutely, and I think what is very encouraging is the recognition by the state, by the government, that and by the people. You have think tanks and you have civil society understanding and underscoring the importance of international law, whether it is human rights treaties or whether it is our obligations in other areas. I think it becomes fundamental that this realization come about. And then with that, we then start moving the next step, which is improving capacity, improving coordination, developing a policy on how to engage with international mechanisms, international treaty-based organs and bodies, and also how we bilaterally treat other countries, whether they are friendly countries or whether they are countries that are hostile to us.
Yeah.
So, but building that capacity, I think, is something that is long overdue.
Yeah.
The only problem here is, as Jamal, you've mentioned, in discussions we've had earlier, that lawfare capacity is not a switch that you turn on and off, right? And I wanted to pick this up because it is something that you have to cultivate over years.
Absolutely.
Like how Pakistan, when it deemed that our conventional military capacity was not enough, we acquired greater military capacity. When we determined that we needed a nuclear deterrent, we acquired nuclear weapons. Similarly, I think now is the time, and in fact, it's been the time for quite a while, that we need to acquire lawfare capability. And we need to make this a concerted national project where we cultivate the academia and the ecosystem behind it, and develop the job market, frankly.
But
so
I think
people will want to get
I'm
into
quite
this.
happy to notice that the current government, the current political parties, the current military leadership, they are beginning to be alive to these challenges.
Yeah,
and I noticed that political parties are, engaging young lawyers
Yeah.
to come together to render assistance on international issues before political positions are taken. The government is doing the same thing, and I think a lot of think tanks are beginning to come up in this area, which is a welcome
And
development.
I think this is where the value of organizations like RSIL comes in, and our experience has been that these things require a generational effort. So when you started RSIL in 1993, it's taken 30 years for us to get here.
True.
But there is 100 years more to go. And now, when you started off, it was seen as a comedy to even focus on
Yes.
international law. Now it is, people are hungry to enter into this field. They realize the importance of it, but we don't have the ecosystem developed for it. There are not enough quality international law programs in our public sector and private sector
And as Awais
universities.
said, you need to give job opportunities.
Yes, there needs to be markets for it. That government departments have to have positions open for it. Academia has to be taken seriously. So generally in Pakistan, the problem that we had is that if you're in academia, you're seen as some person who is maybe talking on theory, and you don't really have good job prospects, so you want to move back into litigation. That thankfully is changing, but I think Pakistan also needs to look inward and interested, because a lot of issues on Kashmir, for example, where there have been, if you look at the history of Kashmir from a legal perspective, it's one of missed opportunities.
Absolutely.
And a lot of things a lot of tragedies which we could have overcome had we had better capacity. Even now, when 5th August took place in 2009, still after 2 years, people are asking what has happened and what can we do.
Absolutely.
Whereas if there was a proper culture and there was a proper, we should have been able to kickstart something which RSIL was able to do just 2 days after 5th August, was to come up with a legal memorandum on the status of Jammu and Kashmir under international law.
Yeah.
This was the thing, and this is posted, it's available on our website. It is something which tries to look at things dispassionately. And that is
And
what
I'm told it is one of the most downloaded documents
absolutely.
in
Absolutely.
Pakistan, from Pakistan, on this issue.
Sir, one question to both of you. In February and in March, especially in the Islamabad Security Dialogue, Pakistan indicated that we are ready to move forward, and economic security is now the main paradigm. It's labeled as geoeconomics as well. And with India as well, there seemed to be an indication that we are ready for some kind of dialogue, provided that there is a conducive environment for that. And the conditions that we laid forward was autonomy for the Kashmiris, giving them their fundamental rights, restoring their status, and obviously our terrorism concerns. But this, on the other side, has been construed as maybe an indication that Pakistan is willing to bury this issue, move ahead, and some factors have even tried to say that there has been some kind of deal, or where Pakistan is said. Do you see this as a fair assessment? And Pakistan's, I think, I just wanted the views of both the parts.
Well, frankly, I think you'll always hear a counter version of everything that you wish to do or any direction you want to take. But let's watch our interest. We should look what is, from our standpoint, is in our interest in long-term sense. Economics is a very major issue. Finance, economics, trade, revival, and entrepreneurs' encouragement is a very critical issue from Pakistan's point of view right now. We need the economy to rise. We need to promote trade, whether it's regional or international, and within inter-province trade as well, because the economy is not run by the government; it's run by the private sector.
Absolutely.
We need to unlock their potential. We shouldn't prevent them from taking advantage that is being offered, let's say in Afghanistan, let's say that's being offered in the country next door, in China, elsewhere. And for that, we need to allow them as individuals to participate. As a state, we are standing by our stated position. And our position remains that unless things are reversed and unless a conducive environment is developed, at a state-to-state level, it will become difficult. We cannot act contrary to the wishes of the people of this country.
Absolutely,
Yes.
sir. I mean, just big picture. I think it is a strategic imperative for the people of South Asia to come to peaceful relations. That is just understood, and that is what the ultimate aim is. Having said that, I don't think any of the statements made, by whether it's in the Islamabad Security Dialogue or elsewhere by the Prime Minister, have been, irresponsible statements. I think they've been pragmatic.
And they have not been responded to from the other side
Exactly.
Yeah.
Absolutely.
as much as
And we're seeing some positive developments as well. I mean, the ceasefire agreement in February. I mean, obviously we think that there is scope to formalize that. I think that can be a low-hanging fruit for as a confidence-building measure.
So I think, especially when it comes to Kashmir and Indo-Pak relations, there's a lot of emotion involved, especially from our people.
Yeah.
And it's understandably so, right? It is
And why
emotionally
not?
charged. And
Why not?
And it's
Yeah.
necessary to an extent. But when it comes to finding solutions, that has to be done, cold, hard decision-making, away
and that
from the
has to
rhetoric.
be done by the political forces, Jamal.
Absolutely.
I mean, eventually, what should be the way forward in Kashmir? I can't tell, you can't
Of
tell, he
course.
can't tell as an academic. It is for the political forces of this country, political parties of this country, who need to sit together and agree, okay, fine, we want to go for option 1, option 2, option 3, whichever direction they wish to go. Options are known to everybody. I think there's no big
Absolutely.
secret.
Yeah.
Now, but the political force has to give its sanctity behind it. It has to stand behind that way forward on that.
Sir, I completely agree. I would like to add, though, that there's until that political consensus does not come
Emerge.
about, which we don't know whether that will be tomorrow or maybe not in our lifetime. But as lawyers, perhaps both sides can start working on potential scenarios from both sides. I mean, we know that climate change it's wreaking havoc already all over the world. We're seeing these extreme weather events. We know that the Indus Water Treaty is holding fort right now, but the developments, the rapid developments that are taking place on the ground will make this a water war very likely in the future. So especially on things like climate, poverty alleviation, because end of the day we are
I would also say transit, Jamal.
transit, of course.
Because if I would prefer to see trucks from Lahore going to Dhaka, why not?
Yeah.
It's if you calculate on a Google map, it's like almost traveling from Islamabad to Karachi, more or less, if I'm not wrong, or from Lahore to Kathmandu, from Lahore to
I think it's
Bhutan.
1,800 kilometers or 2,000
Something
kilometers,
like
something
that.
like that. Yeah.
Yeah.
So why can't our entrepreneur, our producer, our manufacturer be given access to markets which are desiring it? So there's a lot of potential. We are already beginning to do this with the CIS countries, and the Prime Minister traveled there.
But sir, as you know, this requires a lot of technical homework before we can do those
Yes,
things.
that technical homework should be done. Some work is being done by you and your team as well, which is positive. But as I said, we need to move forward on the economic and the trade front for sure.
Yeah, yeah. While at the same time understanding that international law can also, that same technical capacity can help you safeguard your territorial interests for seeking accountability for violations and for protecting the rights of the Kashmiris as well. So I think
And
it's just
take it as a transactional relation. If you are able to arrest and spy from the Indian side, take it to the logical extent that legal process requires. If they are able to identify some wrongdoing from our territory, they should file a case, and we should extend necessary cooperation for that. And if we are able to identify they were doing disinformation lab, whatever legal remedies are available, we should follow that. I mean, so no one is saying hold back everything. The natural legal processes, responses that are required to be given should be given.
Jamal, if I could just add slightly to this. I mean, this realization that, the 1.5 billion people of South Asia require peace and want to move on, this realization also has to be made in India. And actions such as 5th August 2019 are roadblocks in this road to peace. That realization, once it becomes a common realization, then we start moving in a proper direction. And I think from Pakistan's end, the demands that we've made, or the National Security Advisor in his statement has said, and we've seen in the Samad Security Dialogue, these are essentially to ameliorate the conditions, the violence that is taking place in Jammu and Kashmir on the people of Jammu and Kashmir, and second, to get them to a position which they were roughly, prior to the events of August 5th, where we could have still had a discussion. Now the ball is in the Indian court. And I think Prime Minister Modi and his team needs to really seriously determine that if they want to ascend into whatever role of being a regional superpower or whatnot, they can't do that without having peace with Pakistan. And I think they are slowly coming to this realization, and there are moves in this direction where troops have been transferred from Pakistan to the Chinese border, and recent events in Ladakh in their end have signaled that to them, that they need to patch up if they want to be able to play this international game.
If you remember, we held a long seminar a couple of years back or so on legal diplomacy.
Of course.
As a way forward.
Sir, I would like you to kind of explain that concept.
Concept is very simple. You see, we were saying that disputes between India and Pakistan have a legal dimension to it. Every dispute, whether it's Siachen, Sir Creek,
Kashmir,
IWT,
terrorism.
Kashmir, terrorism, they are inherently legal issues as well. So let's open a window of legal diplomacy. Lawyer from the Indian side, lawyers from Pakistani side sit together, maybe in a neutral venue or directly, and look at the various legal options that are available to both the sides. And because you need to act in a transactional approach now. As it comes, you respond. As it comes, you respond on the legal merit of it, as opposed to be driven madly by a political rage or, do you hold back everything? No, we won't do anything. Or we will not give any kind of cooperation. Why not? You're right. There's an obligation on Pakistan, on India, and in case of a criminal proceeding, in case of any cases being registered, cooperation must be extended. So if there could be a Siachen interpretation, one could look at various legal options under that, Sir Creek under legal. So if you remember, we had done these case studies of these issues, including Kashmir.
Absolutely.
That Pakistani and Indian lawyers.
And in that, sir, you had predicted that Article 370's abrogation was something which we were actually anticipating as one of the options back in 2014.
We had predicted there will be a threat of abrogation of IWT, which came about.
We had predicted that GB will be challenged, the status of GB.
Exactly. So it's not that you are legally speaking, you are able to see in the future that what is a likely course of action if my other adversary or someone else has taken these steps. The logical way forward is he's going to do this, this, and this. You can easily predict.
Absolutely.
Just like you look at a lawyer's brief and look at the other side and make up your mind what will they do.
And this is, I think, Avais, what you also like to talk about is that the capacity in international law gives you that ability to predict and scan the horizon.
Horizon scan, absolutely. And I think this capacity is something that needs to be built with the state. I mean, one example is our grey listing, our third time grey listing by FATF. This is something that had we, the right capacity, people could predict. FATF has new standards. We're not meeting those standards. We're going to be grey listed. And this could be done for a whole host of other issues. And there are many issues that are on the horizon. I mean, this EU Disinfo Lab, the revelations that it did of Indian, this is decades-long disinformation campaign against Pakistan, where they used legal mechanisms and legal bodies to criticize Pakistan and discredit Pakistan and concoct, personalities and all that. These were things that, it didn't have to be a third-party European organization that detected it. We should have been, on the point, because we are the party most affected by this.
But what I find very intriguing is that Pakistani leadership, Prime Minister of Pakistan, is actually very keen for improving ties.
That's true.
The opposition leaders of Pakistan are keen on improving ties.
And sir, interestingly, it's based on what you're saying. Pakistan clearly seems to be acting or portraying itself as a responsible state.
Exactly.
And that is helping its standing internationally.
It's beginning to help its standing much better.
Yeah.
And we now have a China element to it. We want to create a regional alliance with every country so that we are able to leverage our potential to the maximum. Now, obviously, within Pakistan, there are different voices. there are voices who have been used to this idea that no, we will not negotiate with India at all. And then there are voices which are being more pragmatic in saying, let's try and make an effort. Now, the life of these new voices won't be very long. It needs to be grabbed. There has to be a response to give more life to this voice and this version.
And that is something which the
Which the
NSA and the
Indians-
Prime Minister keep saying, that you have to set the conducive environment for dialogue.
Yes.
Absolutely.
The
And I
window
think-
is there, but
and
it's
if you look
closing.
at what government of Pakistan or the Prime Minister did, he returned the prisoner of war who was the
Of course.
pilot immediately to signal cessation of hostilities under the Geneva Convention. Look, I'm returning this guy back. And you return people that... So from my side, the hostilities have come to an end. So there was a more proactive approach that Pakistan demonstrated. So I
Again, sir,
think-
Operation Swift Retort was an example of when you adhered to international law, whether in our response, which was proportionate, necessary, and in accordance with self-defense, it was viewed as very
as
positive.
one of the
It's
best
justified, yeah.
well-measured response, as opposed
Yeah.
to making the situation more explosive.
Yeah.
Absolutely.
So I think the onus is now on the Indian side, and onus is now on the international community to nudge India that, look, Pakistan is seriously wanting a resolution options, and you need to sit with Pakistan or engage United Nations through a process whereby we are able to resolve this issue. Like sometimes a development of this nature, which is the 5th August 2019, has completely shaken up the legal proposition of
Yes.
Kashmir.
Yes.
Now, one approach is that it settles in a very, very bad momentum. The other approach is we make an effort to find a solution. of
Sir,
this.
another example of the Pakistan being responsible is that after 5th August, we've seen the senior leadership and at every level, even the military leadership, be at pains to emphasize that Pakistanis should not cross the LOC.
No, that's an
I think
incredible
that is-
position to take. That's very, very heartening from a legal point of view, because earlier there have been
It
allegations.
sees the maturity and the evolution of our responses.
Yeah, absolutely. And
And I think as we used to say in our talks here and there, that if you are on the wrong side of international law, that policy won't succeed. That's the bottom line. So I'm glad that red lines of under international law are being recognized by the state.
and respected. Absolutely.
Interesting. So with that, I think we are done. We have some questions coming up from our viewers. We'll just spend maybe 5 minutes or so focusing on the questions. One of the questions is by Mr. Khalil Khan. He says that can't it be argued that by changing Article 370, the central government of India has altered the basic structure of its own constitution, and therefore the change is inoperative? This is something, sir, that we already discussed. Maybe you can...
Yeah, but Khalil Khan Saab's query has been responded to by, I think, Tasneem, Mr. Noorani, the
A.G.
famous
Noorani.
A.G.
A.G.
Noorani,
Noorani.
who's a famous advocate from the Indian side. He actually said that, more or less, that the changing of Article 370 is bringing a change in the basic structure doctrine of the Indian Constitution.
Absolutely, and I don't know if we discussed this in a lot of detail, but the danger to Indian constitutional law and jurisprudence by this decision is significant. The way they went about that, and so I definitely think that this is something that when the Indian Supreme Court finally does get down to determining it, it will be setting a precedent.
But I think as we were discussing the other day, that Pakistan should continue its legal momentum of taking up issues when there is evidence of Indian intervention here and there.
Absolutely.
So there is one question: did the abrogation of Articles 35A and 370 lead to further integration or disintegration of Kashmir in India? It's an interesting question.
Essentially, it's a political question to see where it goes. But as you've already pointed out, that's going to threaten the territorial integrity of the Union of India sooner or later.
Yeah, the spirit of federalism.
The spirit of federalism.
And again, I think what it symbolizes is even more dangerous. The Islamophobic bent or the Islamophobic underpinnings behind this abrogation that took place. That I think is even more concerning.
In fact, my concern was when 5th August happened, that how will non-state actors all over the world react to it? Because the oppression has now been legalized.
Absolutely.
Occupation has now been asserted. Occupation has now been validated. And so, all the Muslim groups and elsewhere How would they respond to that, and within India, and so on and so forth.
So that's an interesting question, which is also put by the Q&As as well, is that if you look at it historically, in the 1980s, the earlier jihadi movement in Kashmir in the early 1990s and the late 1980s, it was also fueled by the success that the Mujahideen had in the Soviet Union. And back then there was argument under international law that they are rightfully acting in their right of self-determination, and other countries actually are obliged to extend them that support. That was we saw articles in the American Society of International Law in the 80s arguing this. When the Mujahideen was successful in Afghanistan, in the fallout we saw a new movement rising in Jammu and Kashmir. Do you see with the fall, with the situation in Afghanistan and the rise of the Taliban and their apparent successes against the US forces, do you see a similar sentiment once again rising in Jammu and Kashmir, or has international law evolved beyond the 1990s?
No, I think there is international law is still saying that any oppressed has a right to seek assistance. Any oppressed, whether it's self-determination oppression or human rights oppression. But if you are self-determination based affectee and a victim, then you have the right also to receive assistance. And we have UN General Assembly resolutions which actually talk about that, in addition to these articles and other. So and then it has further been strengthened by the R2P concept, responsibility to protect, which has come up much later by the academics, and even by the UN Secretary General Office had a special group convened of experts which worked on it. So I think the Kashmiris, but let's see how the Kashmiri uprising, what kind of shape it evolves into, and whether there are
right now there's such a lockdown that it's not even possible to even see what.
Yes, and we don't know if there's an institutional request from the Kashmiris for seeking assistance or so on.
Absolutely, that's something that needs to be looked at.
And we have a comment. Why doesn't the UN take strict action if there are human rights violations every day, as you mentioned in your talks? Why are they silent when the law is clearly on your side?
Well, I think the UN has a very, I would say, fragile system by which it can enforce international law. And I think this is the biggest criticism that international law gets, is that there's no real mechanisms to enforce it. Human rights violations take place, around the world, but there is a greater concentration of them in Kashmir right now.
Yeah.
And I think it is a failure of the UN Security Council resolution to even table these issues and have a concrete discussion on them. So I think the questioner doesn't really understand the, I would say, the way the UN mechanism system works.
But almost all human rights organizations have condemned the entire process.
Absolutely, and I think that's how the mechanism works.
Yeah.
So they are kind of they can be utilized as evidence of where independent assessors stand.
And I think an example of the strict action that the UN has taken is the unprecedented Office of the High Commissioner for Human Rights, the report that he issued 2 years ago, and that is unprecedented. The way he has named India and said that the atrocities that are taking place there are so blatant there. So I think the UN has taken action in its limited way. Of course, there's a lot more that can be done, and that needs to be done. So I think that hopefully answers the question for our questioner.
Are there any questions else? So we thank all our listeners. I hope that it was an interesting session for all of you. We tried to look at all of these different issues. Of course, if you want to truly discuss the Pak-India dynamic and Kashmir, technically, legally, you can be here for the entire week, maybe more. But this was an attempt. I think, sir, the key takeaways is that there's a lot of positives that has also happened, a lot of concerning things as well. But 5th August, in terms of the rights being compromised by the Kashmir, Pakistan has made it clear that there is no room for compromise there. Pakistan will continue to advocate for the rights of the Kashmiri people at all different forums. And there is a now need to document this and study this and propagate this in the legal realm as well. which slowly that realization is coming. But at the same time, there is a lot of room for optimism, for developments as well, and that ultimately comes down to how Pakistan makes its diplomatic political choices backed by correct technical legal propositions. Thank you, everyone.
Thank you.
Thank you, Jamal.